1980, Cook County. The Illinois Supreme Court affirms a death sentence at 4:17 in the afternoon. The docket shows 33 victims, the largest body recovery in state history at that time. Families had waited years for procedural closure. The file promised finality, execution within months, perhaps a year. But the appeals calendar told a different story. Motions stacked, hearings delayed, clemency petitions filed and refiled. 14 years would pass between sentence and execution. Other cases, equally feared, took different paths. Some ended in parole hearings, some in life terms with no review, some in death on death row, never reaching the execution chamber. This is a story about 7 cases, 7 outcomes in the statutes, votes, and verified records that explain why severity does not always predict sentence and why finality is rarely final. The contrasts are documented, the numbers are real, and the questions remain open. A corrections officer opens a file cabinet at Stateville Correctional Center. Inside, an execution roster, a Supreme Court summary, and a clemency denial letter. The public remembers the body count, 33 young men recovered from a crawl space and the Des Plaines River. The record shows venue, statute, and procedure. Cook County prosecutors charged capital murder. The jury returned death, the Illinois Supreme Court affirmed, the governor denied clemency. And on May 10, 1994, the state of Illinois executed John Wayne Gacy by lethal injection. But if 33 victims yielded execution in Illinois, what explains life without parole, or parole itself, in other cases of equal notoriety? The answer lies not in moral judgment, but in statute, jurisdiction, and the documented decisions of courts, boards, and governors. To understand the outcomes, we must first define the terms. LWOP means life without possibility of parole, a sentence that offers no review, no release, no return. Clemency is the power of a governor or board to commute, pardon, or reprieve, overriding a court's judgment. Mitigation is evidence presented at sentencing to reduce culpability or penalty, mental illness, trauma, cooperation, remorse. Appeal posture describes where a case sits procedurally: direct appeal, state post-conviction, federal habeas corpus, or clemency review. These terms are not abstract. They are the machinery of the system, and they produce radically different results depending on the state, the statute, and the evidence presented. Gacy's case moved through each stage: direct appeal denied, post-conviction denied, habeas corpus denied, clemency denied. The system functioned as designed, execution followed, but not every case with a high victim count or public terror reaches that end. Some remain in parole hearings decades later, some end in natural death on death row, some result in release. The disparity is not random, it is statutory, jurisdictional, and documented, and it begins with the first level: suspicion, pattern, and the question of what prosecutors choose to charge. 1987. Schenectady County. A jury convicts Mary Beth Tinning of second-degree murder in the death of her 4-month-old daughter, Tammy Lynn. The sentence, 20 years to life. 9 children had died under her care over 14 years. Prosecutors suspected serial infanticide. Autopsies were inconclusive. SIDS was noted on several certificates. But the pattern, suffocation, sudden collapse, hospital arrival too late, drew scrutiny. Investigators built the case slowly. They charged only Tammy Lynn's death, the one where evidence was strongest. A confession, medical testimony, no alternative explanation. The appellate division affirmed. The conviction stood. But the sentence structure, 20 to life, meant parole eligibility. Many assume serial guarantees, life without parole or death. New York statutes and charging. Decisions produced a different outcome. For decades, the parole board denied release. Victim impact statements filled the record. Family members spoke. The board cited the gravity of loss. But under New York law, parole decisions must rest on present risk and institutional behavior, not solely on the original crime. In 2018, after 31 years, the board granted parole. Tinning was released under supervision. The decision sparked controversy. Families felt betrayed. Advocates noted she had served longer than many violent offenders. The record shows no rule violation during incarceration. The question, should a pattern inferred from years of loss alter parole math, or must parole weigh only the single adjudicated count? New York never charged the other 8 deaths. Statute of limitations, evidentiary gaps, and the risk of acquittal shaped that decision. The result? A single conviction, a parole-eligible sentence, and a release that turned on behavior behind bars, not the suspected scope of harm. The case introduces the first contrast: equal notoriety, vastly different legal paths. One state charges broadly and seeks death, another charges narrowly and allows parole. Both choices rest on documented strategy and statute. Neither is accident, and neither guarantees the outcome the public expects. 1992, Volusia County. Aileen Wuornos receives her first death sentence for the murder of Richard Mallory. Over the next year, she pleads guilty or no contest to 5 additional murders, all committed along Florida highways between late 1989 and late 1990. The victims: men traveling alone, soliciting or offering rides. The method: close-range shooting. 7 men dead in 13 months. At the penalty phase, defense attorneys presented mitigation: childhood sexual abuse, head trauma, borderline personality disorder, substance dependence. Expert witnesses testified. The prosecution argued premeditation, robbery motive, and the absence of immediate threat. The jury recommended death. The judge agreed. The Florida Supreme Court affirmed. But Wuornos did not exhaust all appeals. She dismissed attorneys. She waived further post-conviction review. She stated in open court that she wanted to die. Mental health evaluations addressed competency to waive. The trial court found her competent. The appellate court agreed. The governor declined clemency. On October 9, 2002, Florida executed Aileen Wuornos by lethal injection. Public memory often labels her a monster. The record shows mitigation, waiver, and judicial review within Florida's capital framework. The contrast: Tinning served decades and was paroled. Wuornos waived appeals and was executed. The difference was not solely in body count or brutality. It was in state law. New York had abolished the death penalty. Florida retained it, and in the defendant's own choice to end the process. The question: when defendants waive appeals, how should clemency boards weigh mitigation already tested in court? Florida law permits waiver if the defendant is competent. The courts found Wuornos competent. The mitigation evidence, trauma, mental illness, was documented at trial, but it did not override the jury's recommendation or the defendant's decision to stop fighting. The result: execution, not because mitigation was absent, but because the legal process, including the defendant's waiver, reached its statutory end. The case closes the first act with a second contrast: 2 women, 2 horrific patterns, 2 states, 2 completely different outcomes. And the machinery of law, statute, charge, mitigation, waiver, explains both. 1973, Santa Cruz. Edmund Kemper pleads guilty to 8 counts of first-degree murder. The victims: his paternal grandparents in 1964, then 6 young women and his mother in 1972 and 1973. The method: shooting, stabbing, strangulation, decapitation, dismemberment. Kemper drove the California coast, offering rides to hitchhikers. He killed them in his car or at his apartment. He turned himself in after murdering his mother. California did not seek the death penalty. The state's capital statute had been invalidated months earlier by the California Supreme Court. Kemper received life terms, multiple counts, concurrent and consecutive. Under California law, life sentences with murder counts triggered parole eligibility after 7 years. But eligibility does not mean release. The California Board of Parole Hearings has reviewed Kemper's case repeatedly. Each hearing includes victim impact statements, psychological evaluations, and a review of institutional behavior. Kemper has participated in interviews, educational programs, and mental health treatment. He has never been violent in custody. Yet the board has denied parole every time. The most recent denial, in 2024, extended the next review date by several years. The question: should parole boards rest decisions on present risk alone, or is certain historical harm disqualifying regardless of documented change? California law requires the board to assess current danger to public safety, but statute also permits consideration of the nature and gravity of the original offense. In Kemper's case, the gravity, 8 victims, including family members and young women who trusted him, has outweighed decades of institutional stability. Psychiatric reports acknowledge his intelligence and self-awareness. They also note the calculated brutality of the crimes. The board's language is consistent. The risk of release, however small, cannot be justified given the harm. The contrast: Tinning was paroled after 1 count. Kemper remains denied after 8. The difference is not only in numbers, it is in state parole standards, the weight assigned to mitigation versus gravity, and the political and procedural context of each board's mandate. Both outcomes follow statute, both rest on documented decisions, and both leave families and the public questioning whether the system balances rehabilitation, accountability, and safety in any coherent way. 2005. Wichita. A floppy disk arrives at a television station. The sender, BTK, a serial killer who had been silent for decades. 10 people had been murdered between 1974 and 1991. Families were bound, tortured, strangled. The killer sent letters to police and media, taunting investigators. Then, silence. For 13 years, the case went cold. In 2004, BTK resurfaced. He sent letters, packages, and eventually, the floppy disk. Investigators examined the metadata. It showed a deleted Microsoft Word document previously saved at Christ Lutheran Church in Wichita. The document's author field read, Dennis. A quick search. Dennis Rader, Church Council President. Surveillance followed. DNA from Rader's daughter, obtained via a medical record subpoena, matched DNA recovered from victims. On February 25, 2005, officers arrested Dennis Rader. The capture hinged on defendant-initiated contact and a single forensic detail: metadata. Rader pleaded guilty to 10 counts of first-degree murder. Kansas had reinstated the death penalty in 1994, but the statute did not apply retroactively. Prosecutors could not seek death. The judge imposed 10 consecutive life sentences, minimum 175 years before parole eligibility. Under Kansas law, Rader will die in custody. At sentencing, Rader delivered a detailed allocution. He described each crime methodically, without emotion. Families wept. The judge called the statement chilling. Mental health evaluations found narcissistic and antisocial traits, but no legal insanity. The record shows no mitigation that moved the court. The contrast: Kemper self-surrendered and cooperated. Rader taunted and endangered the public with his communications. Both received life terms, but Kemper's cooperation and mental health history opened the door to parole hearings, however futile. Rader's conduct closed it. Kansas statute, combined with his post-offense behavior, ensured permanent incarceration without review. The question: should sentencing credit or penalty turn on cooperation versus taunting behavior that prolongs public fear? The answer, in Kansas, was clear. The consecutive structure and statutory framework made parole impossible. But in other states, similar patterns might have yielded different outcomes. The digital forensics legacy of BTK reshaped cold case investigation. Metadata, once overlooked, became a standard investigative tool. Rader's arrogance, documented in his own communications, became evidence, and his life sentence became a lesson. Cooperation matters, but so does the state's statutory options at the time of sentencing. 1985, Los Angeles. Residents of East Los Angeles corner a man attempting to steal a car. They recognize him from police sketches, the Night Stalker. For over a year, the city had lived in fear. Random home invasions, men, women, children attacked. 13 confirmed murders, 5 attempted, 11 sexual assaults. The method: forced entry, often through unlocked windows, brutal violence, then flight. No single victim profile, no predictable pattern except unpredictability. The community held Richard Ramirez until officers arrived. The booking photo circulated worldwide. The trial followed in 1988. Prosecutors charged 43 felony counts. The jury convicted on 13 murder counts and 30 additional charges. The penalty: death. The California Supreme Court affirmed, but California's capital appeals process is lengthy. Automatic review, state post-conviction, federal habeas corpus, decades passed. Ramirez remained on death row at San Quentin. On June 7, 2013, he died of complications from B-cell lymphoma. He was 63. The execution never occurred. The question, if a death sentence runs through decades of review until natural death, should policy default to life without parole instead? California's death penalty has faced repeated legal challenges, protocol disputes, lethal injection drug shortages, constitutional questions about delay itself. Between 2006 and 2023, California executed 13 people. Over 700 remain on death row. The median time between sentence and execution, when it occurs, exceeds 25 years. For many, natural death comes first. The contrast, Florida executed Wuornos within 13 years of her first death sentence. California's Ramirez spent 24 years on death row and died there. Both states had death penalty statutes. Both imposed death sentences. But California's appellate process, combined with litigation over execution protocols, created a de facto life sentence for many capital defendants. Victim families waited decades for closure. Some supported execution, some opposed it, some simply wanted finality. The record shows none received it during Ramirez's life. His death in custody provided an end, but not the one promised by statute, and his case became a symbol of California's stalled death penalty, of litigation's power to extend timelines indefinitely, and of the gap between sentencing and outcome. The legacy: citizen capture as a model, urban terror as a policy driver, and an execution system that rarely executes. Ramirez's case is taught in criminal justice courses as an example of community vigilance and appellate delay. It is cited in death penalty debates as evidence that capital punishment no longer functions as intended, and it remains unresolved in the minds of families who wanted a different ending. 1978, Des Plaines, Illinois. Officers searched the crawl space beneath John Wayne Gacy's home. They recovered 26 bodies. 4 more are found in the Des Plaines River. 1 remains unidentified for decades. The victims, young men and boys aged 14 to 21, most lured with promises of construction work. The method: ligature strangulation, often after sexual assault. Gacy buried them under his house or discarded them in the river. The trial in 1980 was brief. Gacy's defense argued insanity. Prosecutors presented evidence of planning, concealment, and repeated acts over years. The jury rejected the insanity defense. The verdict: guilty on 33 counts of murder. The sentence: death. The Illinois Supreme Court affirmed. Federal appeals followed. Clemency. Petitions were filed and denied. On May 10, 1994, Illinois executed John Wayne Gacy by lethal injection. 14 years from sentence to execution, shorter than many capital cases, longer than promised. But Gacy's legacy is not the execution. It is the identification work that continues. In 1979, the Cook County Medical Examiner could identify 27 victims. 6 remained unknown for years. Families across the Midwest wondered if their missing sons were among the dead. Advances in DNA technology decades later allowed new matches. In 2011, 1 victim was identified through DNA and dental records. In 2017, another. The most recent identification occurred in 2021. The question: do mass victim cases justify specialized identification funding that persists long after execution? The answer, in Cook County, was yes. The medical examiner's office maintained tissue samples, dental records, and case files. Families submitted DNA voluntarily. Cold case investigators revisited missing person reports. The process was slow, expensive, and dependent on evolving technology. But it brought closure to families who had waited 40 years. Gacy's case also reshaped missing person protocols. Illinois created centralized databases. Training for investigators improved. The National Missing and Unidentified Person System, NAMUS, launched in 2007, drew lessons from Gacy's victim identification challenges. The administrative legacy outlived the execution. The contrast, Ramirez's death in custody, left no such legacy. Gacy's case ended in a medical examiner's lab with DNA matches decades later and in policy reforms that made future identifications faster. Execution provided closure for the courts. DNA provided closure for families. The two timelines rarely aligned, and the gap between them, between legal finality and human resolution, remains a feature of mass victim cases. 1989, Florida State Prison. A clerk stamps the final federal habeas corpus petition, denied. The U.S. Supreme Court declines to hear the case. The governor issues a statement refusing clemency. Victim families receive notification through the Attorney General's office before the public announcement. On January 24, 1989, Florida executes Ted Bundy by electrocution. Bundy's crimes spanned at least 5 states: Washington, Utah, Colorado, Idaho, and Florida. Conservative estimates place the victim count at 30. Some investigators believe the number is higher. The confirmed victims, young women, often college students, abducted from public places. The method: blunt force trauma, strangulation, sexual assault. Bundy disposed of remains in remote areas. Some bodies were never found. Bundy's trials were public spectacles. He represented himself in Colorado, cross-examining witnesses. He escaped custody twice. His Florida trial in 1979 for the Chi Omega sorority house murders was televised, one of the first such broadcasts. The jury convicted. The judge imposed death. A second Florida trial for the murder of 12-year-old Kimberly Leach resulted in a second death sentence. The appellate process followed standard capital procedure: direct appeal, state post-conviction, federal habeas corpus. The Florida Supreme Court affirmed both sentences. The 11th Circuit denied relief. The U.S. Supreme Court declined review. Bundy's attorneys filed multiple petitions in the final days. All were denied. At no point did Bundy express remorse. In interviews, he described the crimes in third person. He offered information about other victims in exchange for delays. The record shows no credible mitigation evidence that moved the courts. Mental health evaluations found antisocial personality disorder, but no legal insanity. The question: should courtroom conduct, showmanship, or remorse ever influence proportionality more than the statute and facts? The answer, in Florida, was no. The statute, the facts, and the jury's recommendation drove the sentence. Bundy's behavior in court, confident, articulate, manipulative, did not alter the legal outcome. But it shaped public perception. He became a symbol of intelligence in service of evil, of the justice system's ability to convict charismatic defendants, and of the death penalty's application to those who showed no contrition. The contrast: Bundy was executed within 10 years of his Florida sentence. Ramirez spent 24 years on California's death row and died there. Gacy waited 14 years in Illinois. All 3 faced death sentences. All 3 exhausted appeals. But the timelines, the state protocols, and the litigation environments differed. Florida moved faster. California and Illinois moved slower. The disparity is statutory, not moral. And it leaves a final question: if states cannot execute uniformly, should they execute at all? Appeals hold because the record is clean. In Bundy's case, the Florida Supreme Court reviewed jury instructions, evidentiary rulings, and penalty phase presentations. The court found no reversible error. The direct appeal affirmed both death sentences. State post-conviction motions followed: ineffective assistance of counsel, newly discovered evidence, improper jury instructions. The trial court denied. The Florida Supreme Court affirmed again. Federal habeas corpus raised constitutional claims: due process, cruel and unusual punishment, mental competency to stand trial. The 11th Circuit reviewed the record. The court found the state proceedings fundamentally fair. The U.S. Supreme Court declined to grant certiorari. The final denial arrived days before execution. In Warnos's case, the appellate path shortened because she waived further review. The Florida Supreme Court reviewed her initial conviction and affirmed. When she dismissed her attorneys and stated in open court she wanted to die, The trial court ordered a competency evaluation. The evaluation found her competent to waive. The appellate court agreed. The governor's clemency review found no basis to intervene. Victim families received notification through the Attorney General's office at each stage. In Bundy's case, survivors and families of the Chi Omega victims traveled to Florida State Prison. They witnessed the execution. In Warnos's case, families of the highway victims issued statements. Some supported execution. Some believed the sentence was just. Some wanted closure after years of litigation. The question: if direct appeals confirm sentences, where should clemency boards find independent room to act, if at all? Florida's clemency process requires the governor and a board to review each case. But the standard is not error correction. That is the role of courts. Clemency is mercy, an act of grace beyond legal entitlement. In both Bundy's and Warnos's cases, the record showed no compelling reason for mercy, no new evidence, no procedural breakdown, no mitigating fact that the courts had overlooked. The result: appellate closure resting on procedural regularity, even amid public controversy over mitigation. Bundy's charisma and Warnos's trauma became cultural touchstones, but neither altered the legal outcome. The machinery worked as designed: statute, trial, appeal, affirmance, execution. The timeline varied: Bundy 10 years, Warnos 13, but the process held. And the families, who had waited through each stage, finally received the finality the statute promised. Parole is not automatic. In California, the Board of Parole Hearings reviews life-term inmates on a recurring schedule. The board's mandate: assess current danger to public safety. The standard is not punishment, it is risk. But statute also permits the board to weigh the gravity of the original offense. Kemper has appeared before the board repeatedly. Each hearing includes a psychological evaluation, a review of institutional behavior, and victim impact statements. Kemper's record in custody is exemplary. No violence, no disciplinary infractions. He participates in programs. He conducts himself with intelligence and self-awareness. Psychologists note his insight into his own pathology. Yet the board denies parole every time. The language is consistent. The nature and gravity of the offense, 8 murders, including decapitation and dismemberment, create an unacceptable risk, regardless of institutional behavior. The board cites the calculated nature of the crimes, the vulnerability of the victims, and the decades-long trauma to families. The most recent denial, in 2024, pushed the next hearing years out. In New York, Tinning's parole path followed similar procedure: recurring hearings, institutional behavior reviews, victim impact statements. But the outcome differed. After 31 years, the board granted parole. The decision rested on New York's statutory framework, which emphasizes rehabilitation and present risk over historical gravity. Tinning had no disciplinary record. She completed programs. The board found the risk of reoffense low. Victim families objected. The community protested, but the parole board followed statute. Under New York law, the gravity of the original crime cannot be the sole basis for denial if the inmate no longer poses a risk. The board's decision was controversial and legal. The question: does parity require uniform parole standards across states, or is local control a feature, not a flaw? The answer depends on perspective. Advocates for uniformity argue that similar crimes should produce similar outcomes. Advocates for local control argue that state legislatures, reflecting their communities, should set parole standards. The record shows both views in action. California's board prioritizes gravity. New York's board prioritizes risk. Both follow statute, both produce legal outcomes, and both leave families questioning whether justice was served. Moratoria change outcomes without changing sentences. California has not executed an inmate since 2006. Over 700 people remain on death row. The governor imposed a moratorium in 2019, halting executions indefinitely. Litigation over lethal injection protocols, combined with ballot initiatives and judicial challenges, created a system that sentences defendants to death but rarely carries out the sentence. Richard Ramirez died on death row in 2013, 24 years after his sentence. The execution never occurred. Families attended his trial. They testified at penalty phase. They waited decades for closure. Natural death provided an end, but not the one promised. In Illinois, the timeline was different. Gacy received his death sentence in 1980. Illinois executed him in 1994, 14 years from sentence to execution. Illinois later abolished the death penalty in 2011, commuting all death row sentences to life without parole. But Gacy's execution occurred before that change. The state carried out the sentence it imposed. In Kansas, Rader faced a different regime. The state had reinstated the death penalty in 1994, but the statute did not apply retroactively. Rader's crimes occurred before reinstatement. Prosecutors imposed 10 consecutive life sentences instead. The result: permanent incarceration without execution and without the prolonged litigation typical of capital cases. The policy question: if time itself becomes a sentence, should legislatures codify default conversions to life without parole after a set threshold? Ramirez spent nearly a quarter-century on death row. Gacy spent 14 years. Rader will die in custody under life terms. All three outcomes rest on state policy, not on the severity of the crimes. Ramirez's sentence became moot through moratorium and natural death. Gacy's sentence was carried out before abolition. Rader's sentence avoided capital litigation entirely by statutory timing. Victim families in California experienced prolonged uncertainty. Families in Illinois received execution but waited over a decade. Families in Kansas received certainty, life terms, without the promise or trauma of execution. The record shows no family satisfied with the timeline. And the question remains: should the state promise finality it cannot deliver, or should it abandon capital punishment in favor of sentences it can enforce uniformly? 2021. The Cook County Medical Examiner's Office issues a press release. A DNA match identifies victim number 31, 43 years after recovery. The victim's name is released. The family issues a statement. They had waited since 1978. Gacy's execution in 1994 closed the legal case. But the identification work continued. Tissue samples were preserved. Dental records were maintained. Families across the Midwest submitted DNA voluntarily. Cold case investigators reopened missing person files. Technology advanced. Databases expanded. Matches occurred slowly, one every few years. The National Missing and Unidentified Person System, NAMIS, launched in 2007. It centralized missing person reports, unidentified remains, and unclaimed persons data. The system drew lessons from Gacy's case: the need for long-term sample preservation, the value of family DNA databases, and the importance of investigative persistence. Illinois strengthened its missing person protocols. Training improved. Funding increased. The legacy for victims is not execution. It is identification. Legal closure came in 1994. Human closure came in waves over decades. For some families, it has not yet come. One victim remains unidentified. Public memorials were held. Families gathered. Names were read. The Cook County Medical Examiner's Office maintains a dedicated page listing all identified victims with dates of recovery and identification. It is updated as new matches occur. The page does not mention Gacy by name. It lists the victims, their names, their ages, their hometowns. That is the legacy. Memory preserved, families notified, and systems strengthened so future cases move faster. The question for viewers: if you have records or memories that aid identification, follow your state medical examiner's process. Submit information. Provide DNA if family members are missing. The work continues. Cold cases close slowly, but they close. And when they do, families receive what the courts cannot provide: a name, a date, and the knowledge that their loved one was not forgotten. Gacy's execution ended the legal case. The identification work honors the victims. It is quiet, methodical, and ongoing. It does not make headlines, but it brings closure. And in a system where finality is rarely final, closure is what families need most. 7 cases, 7 levels of fear, 1 ranking based on brutality and cultural impact. But the outcomes do not align with the ranking. The most feared did not always receive the harshest sentence. The harshest sentence did not always result in execution, and the system produced outcomes that families, communities, and even legal scholars struggle to reconcile. Level 1. Mary Beth Tinning. 9 suspected deaths, 1 conviction, 20 years to life, paroled in 2018. New York statute, charging strategy, and parole. Standards produced that outcome. It was legal, it was controversial, and it stands. Level 2. Aileen Wuornos. 7 murders, death sentence, appeals waived, executed in 2002. Florida statute, mitigation disputes, and the defendant's waiver produced that outcome. It was legal. It was swift by capital standards, and it ended. Level 3. Edmund Kemper. 8 murders, life terms. Parole denied repeatedly, most recently in 2024. California statute, parole board standards, and institutional behavior produced that outcome. It was legal. It continues. Level 4. Dennis Rader. 10 murders, consecutive life terms, no parole eligibility. Kansas statute and timing produced that outcome. It was legal. It is permanent. Level 5. Richard Ramirez. 13 murders, death sentence, died on death row in 2013. California statute, moratorium, and natural death produced that outcome. It was legal. It was not the promised end. Level 6. John Wayne Gacy. 33 murders, death sentence, executed in 1994. Illinois statute and appellate closure produced that outcome. It was legal. It was carried out. Level 7. Ted Bundy. At least 30 murders, death sentence, executed in 1989. Florida statute and federal review produced that outcome. It was legal. It was the fastest resolution among death sentences here. The terms viewers learned: LWOP, clemency, mitigation, appeal posture. These are not abstractions. They are the machinery. They produce disparate outcomes because states have disparate laws. Severity does not predict sentence. Sentence does not predict execution. And execution does not predict timeline. Victims' names appear in the record: Chi Omega students, hitchhikers on California highways, young men beneath a crawl space, infants in a Schenectady home, highway travelers in Florida, Los Angeles residents, Wichita families. The law honored them with trials, convictions, and sentences. But the outcomes, parole, execution, death in custody, permanent incarceration, rested on statute, not on the victim's suffering. The question for policy: should similar crimes produce similar outcomes across state lines? Advocates for uniformity argue yes. They cite equal protection, proportionality, and the appearance of justice. But the Constitution grants states the power to set criminal law. Federalism means variation. Local control means different communities make different choices. California voters twice rejected death penalty abolition, then accepted a moratorium. Illinois abolished capital punishment after executing Gacy. Florida retained it and used it. Kansas reinstated it but applied it prospectively. New York abolished it entirely. The record shows both the strength and weakness of that system. Strength: states reflect their community's values. Weakness: families in similar cases receive vastly different outcomes depending on geography and timing. A murder in California yields death row and decades of litigation. The same murder in Kansas, committed before a statutory date, yields life terms. In New York, it yields a parole-eligible sentence. Viewers leave with this: the system is not broken, it is working as designed. The outcomes feel disparate because they are. Disparity is the price of federalism. Uniformity would require Congress to federalize murder law, stripping states of their traditional authority. No serious movement proposes that. So the variation continues, and families live with the consequences. Honor victims in the comments with facts or verified resources. Keep discussion civil and policy-focused. The cases here are closed or ongoing under lawful process. The questions they raise are not.